I was like, what's a masturbator?
I put in there he was an excellent fisherman, but you'll see that the state crossed that off.
This case is not your typical courtroom moment. It's a tense battle involving aggravated robbery, a first-degree felony that carries the potential for life behind bars. But here's where it gets interesting. Despite the seriousness of the charge, the defense is applying for deferred adjudication. What does that mean? If granted, Mr. Woodard avoids an immediate conviction, and instead, he's placed under strict probationary terms. Fail to comply, and he could be looking at decades in prison. We'll watch as the judge questions his competency, breaks down the plea deal, and ultimately decides whether this man walks out on probation or gets locked away for years. Pay attention, because the stakes couldn't be higher, and the courtroom drama here is packed with surprises. Let's dive in.
If you come down, please. Mr. Bach? All right, Mr. Bach, are there any applications?
No, yes, Judge, we're applying for deferred adjudication.
All right. Court is calling 2025 CR 005807 State versus Kendall Woodard. Can I have parties announced?
Deputy Pitlock for the state of Texas, Your Honor.
Charles Bunk for Mr. Woodard.
Are you Mr. Woodard?
Yes, ma'am.
All right. State, do you have any objections to Mr. Bunk appearing by Zoom?
State has no objections, Your Honor.
Mr. Woodard, do you have any objections to your attorney appearing by Zoom?
No.
Counsel, have you received all discovery?
Yes, Judge.
Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Woodard, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor, we are.
Mr. Woodard, you're charged with the offense of aggravated robbery. That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront.
Here's where things get serious. The plea bargain terms are being laid out. A $2,000 fine, an official deadly weapon, finding, 5 years of deferred adjudication, and 200 hours of community service. That deadly weapon designation is no small matter. It follows you forever, even if you avoid prison time. And look at how calmly Mr. Woodard accepts these terms. No objections, no hesitation. But here's the kicker. The judge doesn't have to accept this plea, meaning Mr. Woodard is still at the mercy of the bench. What do you think, viewers? Should someone accused of aggravated robbery even be offered probation?
Any witnesses, the state would call in the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to life in prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
No, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Woodard, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $2,000 fine, affirmative finding of deadly weapon. State recommends deferred adjudication. There's to be restitution, if any, to the complainant. Did you understand that to be your plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 5 years. There be no contact with the complainant, a TAP evaluation, and 200 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
State offers State's Exhibit 1 and all attachments at this time, Your Honor.
No objections.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. So what I can tell you, Mr. Woodard, when I was reading this, well, before I even got to the point of reading the stipulations, I was wondering.
Now this is rare. The judge actually pauses to ask why deferred adjudication was even offered. Think about that for a second. A first-degree felony with a deadly weapon involved, and yet the state is still recommending probation. The judge admits that after reading the police report, she sees the reasoning, but her initial doubt tells us everything about the seriousness of this charge. This moment is crucial because it reveals how much discretion a judge has in balancing justice with rehabilitation. Would you take that risk if you were the judge? Or would you throw the book at him?
Why was deferred adjudication being offered in this case? Now that I've read the police report, I see the state's reasoning and think that it is appropriate sentence. Mr. Bach?
Yes, Judge.
I was wondering, what does masturbating mean? And then I realized it wasn't placed. I was like, what's a masturbator?
I put in there he was an excellent fisherman, but you'll see that the state crossed that off.
So I was trying to figure out what that was. Now I know what they meant by that. So here's the thing, Mr. Woodard, I'm going to find there's sufficient evidence, as previously stated, to find you guilty. I'm going to defer finding of guilt as you've applied for deferred adjudication. Let me explain to you. Even if someone is continuing to do things of a sexual nature in front of people, you can't take matters in your own hands by confronting them. You need to call the police.
Yes, ma'am.
And I understand that this was with homeless people and there were women there who felt somewhat kind of way about this person
Yes, ma'am.
because of the actions they were taking, but you're not allowed to do that. You understand?
Yes, ma'am. I understand.
All right. Counsel, are you proceeding with sentencing?
Yes, please.
Anything you wish to say on behalf of your client?
I believe when you consider the facts as they are, that he's worthy of the plea bargain, and we ask you to follow it.
All right. Do you have any family support here?
No.
Are you originally from here?
No, ma'am. I'm from Alabama.
All right.
I do have my mom and brother is in New Brunswick.
So do you need to transfer this to Alabama or somewhere else to get a new start?
No, I've come here to get a new start, actually.
All right. When's the last time you were employed?
I was employed while I was out there, but maybe 2 months before I come in, I wasn't employed. I was working at a barbershop.
All right. Do you have any children?
Yes, ma'am. I have one.
Age?
14.
Okay.
Here's a more human side of the case. Mr. Woodard admits he has 2 children, ages 8 and 14, who he hasn't seen in a year. The judge wastes no time reminding him that probation requires supporting his dependents. This is more than just punishment. It's accountability, not only to the law but to his own family. The courtroom shifts here from cold legal procedure to something deeply personal. And it raises a big question for us. Should family obligations play a role in sentencing decisions, or should the law remain strictly about the crime itself?
When's the last time you saw them?
About a year ago. Last time I was in Alabama.
All All right, what I can tell you is when you're on probation, one of the conditions that the government, the legislature's deemed was appropriate is that you have to support your dependents. You understand?
Yes, ma'am.
All right, this is what the court is going to do. There's a $2,000 fine, affirmative finding of deadly weapon, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider with minors, 200 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the 200 hours of community service restitution will be deemed satisfied. There's to be restitution to and no contact with Jorge Lopez Espinoza. Sentence you to 5 years, deferred adjudication. Have you used any type of drugs in the past?
Back.
Here's the thing, just be honest with me, because
This is back a few years ago. I did.
And what
I haven't
would that
been
be?
using just marijuana.
anything other than marijuana?
No, ma'am.
Here's the thing, if I send you out in the world and you end up testing positive for drugs,
Yes,
a motion to revoke is going to be filed.
yes, ma'am.
And what I can tell you, I'm not going to feel guilty in the least bit because you're telling me you don't have a problem.
Yes, ma'am. I understand.
All right. There can be a TAP evaluation out of custody and notating his file. He says he doesn't have a drug problem. There's going to be field visits 1 time per month for 6 months. Probation, is there anything else?
That I'm probated or not?
Yes.
Okay, nothing else.
Is there anything else you need from the court in order to be successful?
No, ma'am.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And there we have it. Mr. Woodard escapes a life-altering conviction with 5 years of deferred adjudication. But the terms are strict. Fines, drug tests, community service, parenting classes, and no contact orders. One slip-up, and that suspended conviction comes crashing down, exposing him to the full weight of a first-degree felony. This case shows us how the justice system sometimes chooses rehabilitation over pure punishment, but it also leaves us questioning whether that's a gamble worth taking. What do you think? Did the court get it right? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.